Okay, in today's video I'm going to take a look at adverse possession, or what's sometimes called squatter's rights or squatter's title. That's when somebody is in occupation of a property or premises for some period of time and they essentially wish to lay claim to it, wish to be registered as owners on foot of long possession or long occupation of the property. So there is a situation, there is a procedure for getting registered as an owner of a title of a property by way of adverse possession. So that's what this video is about. That's what we're going to look at. As I say, sometimes it's called squatter's rights or squatter's title. So let's take a look. So Section 13 of the Statute of Limitations Act 1957 provides that no action to recover land can be taken at the end of a period of 12 years unless there is established fraud, mistake or disability. What that means is that after a period of 12 years, no action can be taken to dispossess somebody who is in occupation of a piece of property. So if you are in possession of the land for at least 12 years, you may be able to register the land in your own name, and you make that application to the Property Registration Authority. Land registration rules of 2013 are the relevant rules. Rules 17 and 45 are the specific ones. So application for first registration based on possession is Rule 17. So where an application for registration of ownership of property is based on possession, or where the applicant has no documents of title in his or her possession or under his control, and the authority, that's the Property Registration Authority, is satisfied on inquiry or otherwise that the applicant is in possession or in receipt of the rents and profits of the property, the application may be made in Form 5. So Form 5 is the necessary form to make an application to the Property Registration Authority to be registered as the owner based on possession. That's for first registration. You must prove then dispossession or continued dispossession of the owner. So it's not enough that you are there with the consent of the owner. It's not enough that you're there paying rent, or you may have paid rent and then given up paying rent, because that isn't adverse to the title of the owner. That is a recognition of the owner's title. So your dispossession or continued dispossession must be adverse possession taken by you. It must have continued for at least 12 years, and no disability, mistake or fraud will exclude your claim. In other words, there is an exclusion to do with disability or mistake or fraud. In other words, if you fraudulently dispossess somebody, or if there's a genuine mistake. The dispossession of the true owner, and this is very significant, must show an intention to exclude the true owner from enjoyment of the property, and the possession must be inconsistent with the owner's enjoyment of the land. Now, possession will not be inconsistent with the owner's enjoyment of the land if you were, for example, in occupation but paying rent or there on some sort of a lease or license or something of that nature. Unregistered land, you use Form 5. The application for freehold interest in unregistered land based on adverse possession or squatter's title requires documentary title of at least 15 years, starting with a good root of title and showing the person entitled to the property on the date of dispossession, that person's interest on that date, and evidence that possession taken was adverse. In other words, you sought to exclude the true owner, if there was an owner, on that date. The proofs required: you need proof of adverse possession for at least 12 years. This may require an affidavit from you, corroborating evidence or affidavits from neighbours, documentary records, vouchers and so on. You'll also need a PRA approved map. You may need a General Valuation Office certificate. You need details of all rated occupiers during the period of adverse possession, and details of all persons registered as owners during the period of adverse possession, death certificates where necessary. In other words, the true owner may have passed away, and a tax clearance certificate from revenue commissioners in respect of capital acquisitions tax. Registered land is slightly different. Rule 45 is the relevant rule in the Land Registration Rules of 2013. Title to registered property is acquired by possession pursuant to Section 49 of the Act. So that's the specific piece of legislation, that's the Act. Out of the Act comes the rules. Any person claiming to have acquired a title by possession to registered property may apply and they use Form 6. So you Form 5 for unregistered land, you Form 6 for registered land, and you submit the forms to the Property Registration Authority. So Form 6, again, it's an affidavit. You'll describe how occupation began, how you claim to have established your title. For example, deliberate squatting with intention to acquire the property, taking possession as one of the next of kin of a deceased owner, against the personal representative of such owner, other next of kin, uses that you've made of the property, the persons against whom you claim to have acquired your title, and so on. This is all to be set out in the affidavit. Ultimately, it goes into the Property Registration Authority. They'll have a look and then decide whether you are going to be registered or not. There are special cases, unproved wills. Strictly speaking, an unproved will is not adverse possession. However, you can make an application using this same general rule under Section 49 of the Act. So a Section 49 application may be accepted by the PRA in a situation of an unproved will if a possession of at least 12 years is shown. Spouses, you cannot be in adverse possession to a spouse. Lost deed possession, it's not adverse possession, but again an application to the PRA may be accepted under Section 49 of the Registration of Title Act 1964. That is the relevant act, and as I say, out of that act then the particular rules were drafted, the 2013 rules, and they're the rules that the Property Registration Authority will apply when it comes to you looking to register. Possession by personal representatives. A personal representative could bar the beneficiaries by 6 years adverse possession, and next of kin with an entitlement to a share in an estate can bar the rights of other next of kin by adverse possession. So I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. Thank you for watching.